The panel included 9 justices of the Supreme Court, and lawyers were led by Medad Segona, who told court that after the election, the petitioner was placed under house arrest and only managed to get out after an order from the High Court.
My Lord, I appreciate the concern. It is legitimate and genuine. However, I'm persuading you to take the former possibility of a mistake on the in terms of dates. Why? Because these are applications which have been before you, placed before 8. Certainly it was a dating irregularity on the part of the Commissioner. We accept it, but we think it is curable under 126(2)(e) of our Constitution. The applications have been on your desks, my Lord, in your chambers. There is no way they have been substituted.
Yes.
So we should not compute the 15 days from the day the results were announced.
Yes.
To the 1st of February, when you file, but we should actually compute it in such a way that he had only 5 days within which.
He added that by the time he got out, he was left with only 5 days to gather evidence, which was a disability factor.
What do you want then this court to do?
To permit.
To consider the 10 days he was under disability or not? You're not. That's not.
My Lord, thank you, my Lord. With your guidance, to consider the circumstances.
It can't be my guidance. It should be your case. What is your?
My case is this, my Lord. To consider the 10 days of disability as having disabled him to put his case effectively and effectually before this honorable court. And therefore, now that he has his freedom and he has identified the gaps in the process, that's what he wants to present to this.
Segona had a continuous exchange with the judges, and other lawyers also argued that the petitioners would never be stopped from making amendments aimed at ensuring that courts carry on good inquiries into the cases before them.
Yeah, this authority, and there are 15 of them.
Yes, my Lord.
And all the 15, the petitioner, stroke applicant, was not being restrained like we are. What do you want the court to do?
That's what I'm saying, my Lord.
Yes.
These matters did not arise during the period in incarceration. Then the other one is, if the court is going to consider a petition, should it allow grounds that do not dispose the cause of action? Should it allow grounds that do not meet the requirements of the law? For that reason alone, we are not only entitled to object, but we are helpful to the court to object. Most obliged.
The Chief Justice Alphonse Owinidolo asked when the petitioner discovered the problem, to which Segona answered that it was during preparation after filing the petition when they revisited and analyzed the Constitution.
Take the concern. It is legitimate and genuine. However, I'm persuading you to take the former possibility of a mistake on the in terms of dates. Why? Because these are applications which have been before you, placed before 8. Certainly it was a dating irregularity on the part of the Commissioner. We accept it, but we think it is curable under 126(2)(e) of our Constitution. The applications have been on your desks, my Lord, in your chambers. There is no way they have been substituted.
He notified Segona of the Unprofessional Act of playing games with the Registry, a claim that Segona did not deny, but rather accepted, and asked for apologies.
Complaining that 3 days is given to the respondent, I don't know if it were permissible.
Please restrict yourself to the new matters.
True, my Lord, and that's what he raised. The Attorney General raised this, my Lord.
That is just a counter argument. That's not a new matter.
Most obliged.
They argued you are lying. They argued.
If you had only, most obliged, my Lord. If you had only permitted, my Lord, I would simply say that they were satisfied with the 3 days. That's why they never complained in previous petitions. After all, he makes the rules, and he's happy with them. My Lord, earlier on, I had...
No, let me take you back a little.
Yes, my Lord.
You said you're not seeking extension of time.
No, my lord.
What was the whole purpose of saying he was under disability?
The disability, my lord, relates to the time taken away. And with your permission now, I can answer their question.
You want back, not so?
No, I'm not, my lord. The argument from the respondent has been that actually the applicant stroke petitioner has had more time than in previous petitions, which necessitated the previous amendment in the Amama Mbaba's case.
They noted that by allowing the application for new evidence, court will have done justice to the case by allowing evidence that would enable it to carry out an inquiry into the 2021 presidential election. Segona said there is no way an inquiry into an election can be made when some evidence is left out, yet it could have been brought to the attention of the court. He added that the only way the credibility of this presidency can be checked is by allowing such an application. Carol Tumwine for Select News.